fee.
I don't think that they should get his cell phone. I don't think there's any reasonable reason why, just because he says that he has a CI and he's out to get him, it's basically his word against his word. I don't think there's any...
Anybody disagree?
Man, this group decided that they would definitely get the trooper's cell phone if they could narrow down. It depends on the scope of the seizure, I guess, but if they had legitimate arguments that he had a confidential informant, that he knew the defendant was out to get him, anything that could be used as like looking for phone calls from said CI within that time frame is perfectly legitimate.
I disagree.
Oh.
And so did the prosecutor in this case. Yes.
I think at the point where the
Kid Johnson.
Yes, ma'am.
I just like saying that.
I say at 32, I like hearing it. I think the point
Do you know how young 32 is? Okay, go ahead. It's all relative.
Yes, ma'am. At the point where the trooper decided to bring his phone to work and use that phone, like while he's functioning in his official capacity, and even use it as part of the performance of his duties, I think there's a certain implied consent on his part that that phone may be, subject to reasonable search.
Well, I disagree. And I agree with the prosecutor in this case. Yes. We could.
What about protecting the identity of the alleged confidential informant?
Well, number one, what proof is there that this even happened? We've got the defendant, Marty Ortiz, with a long record, telling his attorney, cooking up with his attorney, this possible defense, right? Because if it's true, and he stopped him based on that and not any observed erratic driving behavior, they're going to say the stop wasn't valid, and so all the evidence flowing from the illegal stop, which is, I call it rotten berries of the bush, the court calls it fruits of the poisonous tree, gets suppressed and the case gets thrown out, right? But all we have is a defense attorney saying, here's why we want it. We got a cop willing to say under oath, I didn't get any calls during the stop. At which point I, the prosecutor, am going to say to the judge, we're not in front of a jury. And he's advancing the claim. I'm not trying to subpoena him and put him on the stand. At which point I'm going to say to the judge, Your Honor, let the defendant take the stand and testify under oath that a call was placed and received. Then we will let the court look at the appropriate time frame, and if he's lying, I'm going to add a perjury charge. Why, based on just a cooked-up allegation that has no evidence, it's just a claim, should my officer have to disclose anything on his phone to anybody, including you, Your Honor? When that phone, and I would be saying, I'm drawing a line in the sand, Your Honor, because this is going to set precedent. If you rule in favor of the defendant, every single case that comes to the court, they're going to make some claim with no support because you're going to say they don't have to have any support. And cops are going to have to be turning over their cell phones to defense attorneys who are representing people with a jacket, and some of that jacket may be violent, and it's got all kinds of personal family information, financial information. No. Let him take the stand, subject to my cross-examination. Let's test the evidence, because right now we just got a defense attorney saying we want it because we're claiming this. Where's the evidence? That's what I would have done, and I think that's what the prosecutor did in this case. And I admire the prosecutor for drawing a line in the sand. I got to think about precedent, right? So if it goes this way, I don't believe because you take a cell phone, your personal cell phone with you on the job, that opens it up to every criminal defendant that you might stop. Everybody carries personal cell phones. They're a good emergency equipment. They keep you in touch with your family. I mean, there's a, you know, and I don't, but here's what happened. And then I'll tell you why I think it happened, because I think it was a, oh dear, I shouldn't use this term. Consider my language when it's profane. I'm doing it intentionally for a training effect, because you're going to be dealing with profanity on the street, and you need to have it not shock you so that you're just incapacitated. She said S-H-I-T. When I read the accounts of this, I have never read the court transcript. When I read the accounts of this, I think what happened is that the prosecutor and the judge got into a pissing contest. And because the judge is the judge, they always win those contests. Because what happened is the judge ended up granting a defense motion to dismiss the case, and Marty Ortiz walked. And the prosecutor said, dismiss the case, because we're not going to set a precedent now for every officer to have to give up their personal cell phone that they carry because of every stop. It would have been much harder to do in a murder case, wouldn't it, than a DWI. But she didn't want a precedent set. Goes up on the state appeals, the trial court. The New Mexico Court of Appeal issued a ruling that supported the judge's decision and his reasoning regarding personal cell phones. Here's why I think it got into a pissing contest. The Court of Appeals said that the prosecutor's behavior in refusing to cooperate was conscious, intentional, and unjustifiable. Her privacy arguments were not persuasive in the court's view. And I think what probably happened is the court probably said, okay, I understand you don't want to have the defendant get to see this stuff. I'll review it in chambers. And then when the prosecutor, no, that still invades their privacy, right? We're not afraid you're going to take a hit out on the officer, but why should the officer have to give up their privacy right with nothing more being offered to even you, Your Honor? And that's, you know, judges, you don't trust me, and then the judges reviewing it are judges. So I think it got into a power play. That's just my guess about this. So what the state prosecutor's office, I think, wisely decided to do, they didn't take it up to the state Supreme Court. Because if you take this issue up, given the precedent it can set, you want to take it up in a case where a judge has to dismiss a child sexual abuse case or a homicide. You want to put as much at stake as you can for the judge to realize that if you set precedent in a DWI, it's going to apply in these other cases. So dismiss a homicide, judge, and see what the community thinks about you dismissing a homicide for this. So I think they're going to wait for a case with better facts. But here were some final comments about the talking heads and the legal analysts is, right now, this case affects officers in New Mexico. Maybe it will not gain traction in other jurisdictions, but you should be discussing the issues involved with your administration, your prosecutors, and your union so you know where you stand before you find yourself facing them. So when I did this training, including this issue in this case at the Alaska Police Standards Council Annual Executive Leadership Conference with brass from all over the state, I said, do you have any policies? And I had an assistant attorney general attending that conference who represents DPS in like civil stuff and shaping policies and procedures and making sure they're legal and stuff. And he stood up and he said, well, I'm just going to tell them don't take their personal cell phones to work with them. And I know him. We used to work together. He came on as a baby about the time I was leaving. And I said, well, you know, with all due respect, that might be simple, but I don't think it's realistic. So why don't you figure out, you know, a policy and procedure that says, yes, you may carry your personal cell phone, but you can only use it for, you know, these purposes that don't include receiving a call from, and then you can testify, no, our policies and procedures are that I don't use my phone for anything like that. I won't even answer it. However, work out something that takes into account what a court might be interested in and how you use the phone and you're allowed to use it. Because it's coming. But like I said, the technology train has left the station. I don't know how, it may be simple, but I don't know how realistic it is to just say, you can't have your cell phone with you, your personal cell phone with you while you're on duty. You can try that. It's the easiest.
We're at 60 minutes.
Okay. Thank you.
What if you use something in conjunction to even as simple as using your GPS on your phone to get to a call? Can they still subpoena your phone?
This is brand new stuff. They can subpoena it. Whether the judge will uphold the subpoena, departments haven't thought about this. And so all I'm saying is take that scenario to your department when you get out there and say, what about this? And if you need to know the case and you want to discuss it, contact Ms. Van Brocklin. Go to her website. Her cell phone number's on there, her email addresses, her private mail addresses, and contact her. I'm passionate about us figuring this out so we're not in these kinds of situations after the fact. Okay. Let's look at some scenarios where 60 minutes. See, sometimes you have to remind me because I forget.
Yes, ma'am.
In 20 seconds, I totally forgot. Okay. So rein me in. Take 10 minutes. We'll